I'm Katrina Watson, the President and Executive Director of the Literacy Council of Central Alabama. We're delighted to have Professor Wendy Greene with us here this evening. The Literacy Council of Central Alabama is proud to celebrate its 30th anniversary this year. For 30 years, we've been improving the lives of adults and their families through literacy education that teaches people to read, write, and speak English. Literacy is key to every aspect of adult life, but more than that, it touches upon many other issues in our society, including social justice. We are grateful to have received funding from the Alabama Humanities Alliance that allows us to have intentional programming related to social justice. Through this program, we are going to use literacy and literature to increase paths for human connection. Following this presentation, the conversation will continue throughout the year as TLC, the Literacy Council, provides books recommended by Professor Greene. There will be panels and book discussions. In addition to those of you on this call receiving a book, the people that we serve will also receive a book, and they will read it in small groups and in one-on-one tutoring situations. This will allow us to continue exploring how books and other literary works influence perspectives on social justice. It's exciting to have Professor Wendy Greene with us, not only because of her world-renowned status and the research that she does, but also because her mom was a adult literacy educator as well. Her mom created the first adult education literacy programming in Columbia, South Carolina. Adrian Marshall, the Literacy Council's Adult Education Director, will introduce our esteemed presenter, Wendy Greene. And again, thank you all for joining us as we're using books to address social justice.
Thank you, Katrina. Hello, and thank you for spending your lunch hour with us. It's an honor and a privilege to introduce today Professor D. Wendy Greene. She's a trailblazing U.S. anti-discrimination law scholar, teacher, and advocate who has devoted her professional life's work to advancing racial, color, and gender equity in workplaces and beyond. Her legal scholarship has resulted in the creation of civil rights protections for victims of discrimination throughout the United States. A visionary, she is the architect of two new legal constructs recognized within anti-discrimination law theory and praxis: misperception discrimination and grooming codes discrimination. Her internationally recognized publications in these areas have shaped the enforcement stance of the Equal Employment Opportunity Commission, the EEOC, and administrative law judges, federal courts, and civil rights organizations in civil rights cases. Moreover, the definition of race that she proposed in her 2008 article, Title VII, What's Hair and Other Race-Based Characteristics Got to Do with It, is being adopted in history-making state and federal legislation known as the Crown Act, which is an acronym for Creating a Respectful and Open World for Natural Hair. These are the first laws in the nation to expressly recognize race discrimination is inclusive in the discrimination of African descendants based on their natural and protective hairstyles, such as afros, twists, locks, and braids. Professor Greene is an amazing public advocate against discrimination as it relates to grooming codes. She has been featured in Teen Vogue, Now This News, and the BBC World News regarding the instrumental role she has played in increasing public awareness in this arena. From serving as a legal advisor and expert in civil rights cases, challenging natural hair discrimination, co-drafting federal and state level Crown Acts, testifying in support of this legislation throughout the country, delivering public lectures around the world, to publishing seminal work, which has informed to date every legal pronouncement in the US on a municipal, state, and federal level that natural hair discrimination is race discrimination. She is the founder of the Free the Hair campaign, hashtag Free the Hair campaign, which is a campaign designed to support the right for persons of color wearing their hair as it naturally grows out of their head, or as they so choose. As I like to say, it's a whole thing, y'all. This hair-based discrimination is just its own thing. So Professor Greene is the first tenured African-American woman on the Drexel University Thomas R. Klein School of Law faculty. And prior to her current position at Drexel, she was one of the youngest women and women of color to attain tenure and full professorship at our own Sanford University's Cumberland School of Law from 2007 to 2012. And during her tenure at Cumberland, she received several awards for excellence in scholarship. Professor Greene teaches several courses in the law school curriculum: constitutional law, employment discrimination, equitable remedies, real property, and seminars on race and American law, critical race theory, as well as appearance and grooming codes, discrimination in the workplace. Professor Greene has delivered over 100 professional presentations throughout the United States and in 4 continents, while regularly providing legal commentary to media outlets such as the Washington Post and BBC Scotland News Radio. She has served on numerous committees as well as editorial and executive boards that are associated with matters of law, education, and civil rights. A native of Columbia, South Carolina, Professor Greene is a graduate of Xavier University of Louisiana, Tulane University School of Law, and the George Washington University School of Law. I do not personally peruse scholarly law journals, but I have known Professor Greene since her tenure at Cumberland. And if I had to familiarize you with her, I might ask you if you had the chance to see her last year during the Juneteenth celebration of 2020, when she was invited by the Birmingham Civil Rights Institute to virtually interview the celebrated activist, Dr. Angela Y. Davis, on the topic of freedom. The struggle continues. She was great. They were both great. And I might also ask if just last month you were able to see the segment on PBS NewsHour on hair-based discrimination. The award-winning journalist Yamiche Alcindor interviewed Professor Greene as part of that segment, and it's my favorite segment for highlighting the issues that Professor Greene advocates to address. I might also ask if just this month you were able to catch the HBO show Last Week Tonight with John Oliver. He delivered over 20 minutes of quirky and comedic commentary on the subject of hair-based discrimination. And John Oliver cited the scholarship of Professor Greene as part of that discussion. And you could also catch a glimpse of her on that segment. I believe that Delaware and Nebraska passed their own versions of the Crown Acts during the last couple of months. And lastly, I would ask if you were aware that just yesterday, Professor Greene was awarded the Dive-In Klein Law Champion of Diversity Award. That award is given to a person who demonstrates diversity, inclusion, and cultural competency in the law school and the legal community by promoting equal opportunity in race, religion, culture, sexual identification, and expression. So, Professor Greene, I think I'm up to date on your achievements, unless something has happened this morning. So, without further ado, welcome you here for this discussion, Professor Wendy Greene.
All right. Well, it's so wonderful to be back virtually in Alabama and in Birmingham. And again, thank you so much, Adrian, for that very, very generous introduction. Yeah, I believe I'm going to have to take you on the road with me and also get you to update that bio. Thank you so much. And thank you again so much. I cannot tell you how much I really appreciate all of your support and encouragement along the way. As Adrienne has noted, we have known each other since I first moved to Birmingham back in 2007, and she has been a steadfast supporter of all the work that I have been endeavoring to do in the space of racial justice, equity, law, and society. Katrina and Danielle, thank you so much also for pulling all of this together alongside Adrienne, and for the invitation to present this work that we know is Free the Hair movement, really trying to combat race-based natural hair discrimination, not only in the United States, but around the world. And last but not least, also wanted to extend thanks to the Alabama Humanities Alliance, as well as the Literacy Council for co-sponsoring my presentation today. And so just before I get started, before we got started, I was reminded of the fact that for me, reading really was the impetus for me to become not just a civil rights lawyer and ultimately a civil rights law professor, but one that was focused specifically on combating racial discrimination and injustice and inequities, and specifically as it relates to African descendants and those that we encounter domestically and internationally. And it's because of the power of words and the power of reading that I was able to embrace at a pretty early age. My mother talks about how I was 3 years old learning how to read, in large part because I wanted to read like my older brother and sister, but also because both of my parents were educators, and my mother in particular was an English teacher, that I love to read. And I cannot even imagine my life without reading, because it is through reading that I was first introduced to civil rights advocacy, civil rights lawyers, and more specifically, Justice Thurgood Marshall and his role in trying to dismantle this custom, this law, this system of laws that we know as Jim Crow, not only in the Southern United States, but around the country. And it was reading at 5 years old, a book that my mother gave me on African American civil rights pioneers, that I learned about Justice Thurgood Marshall. And what really knew then that in light of, I was just enraged by the injustices that he and his team were seeking to dismantle, and the fact that my parents and grandparents and those before them were subjected to, this kind of stigmatization and exclusion simply on the basis of their skin color, and more broadly based upon this concept known as race. And it's that concept, alongside the system of racial injustice, that really triggered my interest at 5 years old to uncover what is this thing called race, and why does it appear that African descendants systematically endure racial inequality and discrimination in workplaces, schools, and in broader society. So it is because of reading that I set my sights pretty early on becoming a civil rights lawyer, or rather, in the words of Charles Hamilton Houston, a social engineer, one who would utilize my education, and even specifically my legal education and training, to break down racial barriers to freedom, equity, full inclusion, economic security, by first mastering civil rights protections like the Civil Rights Act of 1964, and then endeavoring to re-engineer civil rights legislation in order to fill gaps in civil rights protections against racial discrimination. So I will just start there. I just thought that it was timely for me to share a little bit of my personal history. I don't do that very often, but you guys have compelled me to do so, but really just showing you how very much writing and literacy matter, and how much it can change your life for the better. And so I will start my presentation here. Let's see here. Hopefully you all can see it from there. Do you see? Let's see here. All right. Hopefully everybody can see that. So I will be talking about how Black hair is transforming workplace policy, law, and culture. And as Adrienne pointed out, one particular area of my scholarship and public advocacy is grooming codes discrimination, or what I've coined as grooming codes discrimination, which is a specific form of discrimination and inequity that results from the infringement upon one's personhood due to the enactment and enforcement of appearance and grooming mandates or expectations, which bear no relationship to one's qualifications, competencies, or performance. Such mandates or expectations implicate protected classifications under our civil rights protections like race, color, age, disability, sex, and/or religion. Though largely my work has focused on grooming codes discrimination in the workplace, it is important to note that grooming codes discrimination occurs in other areas like schools, housing, public accommodations, law enforcement, and even in the exercise of our constitutional rights, like serving as a juror. For example, in South Carolina, an African-American man was barred from serving as a juror simply because he was wearing dreadlocks or locks or the hairstyle like you see me wearing today. And so it is in light of this systemic form of racial discrimination that African descendants commonly and uniquely encounter on the basis of our natural hairstyles. And what that means is on the basis of locks or braids or twists, afros, our curly, kinky, coily hair as it naturally grows. It is because of nearly over 15 years of research and writing, teaching, and activism alongside public advocacy on this particular issue. As a culmination of that, it has turned into, again, what I call the hashtag Free the Hair mission. And what ultimately I've done through this scholarship and public engagement is increase public awareness around the systematic and global discrimination that African descendants suffer because of our natural hair texture and hairstyles. The ultimate goal is to really try to dismantle what we know as colorism, as well as texturism, or the intersection of colorism and texturism. Or another way of thinking about it is the privileging that is often associated with straight hairstyles because of its association with whiteness, and the denigration and stigmatization of natural hairstyles or protective hairstyles like locks, braids, and twists, as well as curly hair because of its association with African ancestry or Blackness. And so the ultimate goal is to not only secure legal, social, and policy change, but also personal change, so that African descendants around the world can freely rock our natural hair or freely wear our hair according to our personal needs and desires. So just to really just start so you can hear some of the narratives of African descendant women who have been trying to navigate this very systemic bias, negative biases and stereotypes associated with our natural hairstyles in their professional capacities. And in this particular segment, it is talking about African descendant women lawyers, and that I had the privilege of consulting on.
Women, we've already policed our bodies so much in these spaces. We still have these unwritten rules and policies that exist to the detriment of people who don't fit the status quo. I've never seen a policy that clearly articulated what I could and could not do with my hair, but I have seen the reaction. And I have felt the negative response of wearing my hair a certain way.
So I'm just retouching up and retightening her locks.
My hair is in locks right now. I've been wearing it in locks for about 2 years. And before this, I was wearing twists. I went natural about 4 years ago. I decided to go natural because I had just gotten to a place where I was kind of done chemically straightening my hair. I have felt discouragement from wearing natural hair. There were concerns about, if you go to an interview with braids or that those hairstyles would impede you from getting jobs, would keep you from getting on big cases, would keep you from getting access to clients.
There have definitely been moments that I've had to like stop to think about it, stop and think about what someone was saying and what it really meant. One example is just like I went to this event with very straight hair, and I remember this particular person saying to me, your hair looks really nice like that. And those two words, like that, really, really sat on my heart for a really long time, because what it meant for me is that all the other times he would have seen me, interacted with me, it would have been my hair in its natural form, the way that I like to wear it, the way that I feel confident and proud. He never commented on my hair when it was in its natural form. And so I thought about that, and I wondered, like, who else thinks that my hair in its natural form is not the best way, or who else thinks it looks better like that?
As a Black woman working in the law, I'm always conscious of like the underlying thoughts about what it means to have natural hair, about the fact that not everybody understands it. I am wearing my hair natural in my front photo. That was a really intentional choice on my part, because that is how I wear my hair on a daily basis. And so I wanted basically my online presence to reflect how I am in real life.
I recall one time when I went to court, and I remember that morning just feeling so anxious, and not necessarily about the case. I thought we had a slam dunk case, frankly. Like, I did the analysis, I did the legal arguments, that was fine. But I was terrified about showing up in a way other than like absolutely muted. I was terrified that I would stand out by virtue of just like being Black, being a Black woman, having a certain cadence. I was just terrified of my Blackness or my natural hairness getting in the way of advocating on behalf of my client.
I think firms need to make sure that they are safe spaces for young Black attorneys and young Black women attorneys in particular to be themselves. And I think ensuring that hair discrimination doesn't occur is a component of that.
My firm supported me in working on the Crown Act. The Crown Act is legislation that makes it illegal to discriminate against people for wearing natural hairstyles in workplaces and in schools. From the legal perspective, what we did is go in and define race to include traits that are historically associated with race, including hair texture and certain protective hairstyles like locks, braids, and twists. So it really makes it very clear that hair discrimination is race discrimination.
I think it all really comes down to young Black women feeling and being supported in their careers. The biggest challenge for me, and I think that's probably a struggle for a lot of young Black women, because when they look ahead or look, up to, what's happening at the higher levels of law firms and in other organizations, they don't see anyone that looks like them. So it's almost like, is it really possible? Do people like me actually get to these places?
So you can see the deliberations that African descendant women systematically are encountering as it relates to our natural hairstyles and hair textures, and the ways in which we oftentimes are trying to suppress the ways in which our hair just naturally grows out of our scalps because of the negative reactions and consequences. And in a recent research study out of Duke University just reaffirms that some of these deliberations are not just perceived, but the consequences are very much real. Black women with natural hairstyles, according to the study, are less likely to get job interviews than white women with curly hair, white women with straight hair, as well as Black women who don straightened hair. And this is very much shaped by either conscious or unconscious biases as it relates to what constitutes professionalism, what constitutes so-called acceptable hairstyles in grooming in our workplaces, and also negative associations as it relates to our competencies and our qualifications and our attributes when we are donning natural hairstyles like locks, braids, and twists, as opposed to as opposed to straightened hair that is oftentimes privileged and celebrated and affirmed because of its likeness to whiteness. And to be clear that this kind of discrimination is not just something that only African descendant women are encountering, but also African descendant men and boys, as well as girls, and not only in the workplace situations here, as you see in Texas, where Kerryon Washington was told that he needed to cut off his dreadlocks because his locks were conceived to be an extreme hairstyle. But also we are subjected to not only being told that our hair is extreme or unprofessional and therefore needs to be either removed or covered or cut, we too are being subjected to very explicit racial stigmatization and racial epithets, as you see here, involving meteorologist, Afro-Latina meteorologist Corliss Ortiz, who was told when she decided to not wear her straight hair, as you see in the picture before you, and to wear her naturally curly hair on air, she was told by one of the observers in an email to the weather girl tonight, please don't wear your hair like that anymore. It just doesn't look good at all. Change it back to something more normal, not something that's all inward, iggery looking. So for those who oftentimes don't think about, this kind of discrimination as a form of racial discrimination, Ms. Ortiz's experience really helps to illuminate how very much it is rooted in anti-Blackness and negative associations with Blackness or African ancestry. So again, Black women, men, boys, and girls around the world, not just simply in the United States, who don their natural hair or natural hairstyles are not only called derogatory epithets and subjected to these types of racial epithets, but are stigmatized very commonly as being unkempt, disheveled, unprofessional, aberrant, radical, militant, unruly, distracting, wrong, extreme, unusual, unattractive, and unacceptable. In the cases of African descendant women, what many are often told is that they will have to, if they're going to don natural hair, their natural hairstyles like locks, braids, and twists and afros, that they are expressly told that they cannot, or to the extent that they do, they're going to need to cover them and cover them with wigs, for example. You see this on posts from Facebook from Jessica Powell, who talks about how her natural hair, she was told that it was too distracting for the office, so her options were either to get a wig or to lose her job. Additionally, in the UK, with the Harrods department store in London, a Black woman was expressly told that as a condition of employment, she would have to chemically straighten her hair. And so this is not something that is, again, unique. Unfortunately, it's very much systemic in nature, the kinds of demands as it relates to our hair that we're having to either explicitly or implicitly conform to. And what I call this is really the hyperregulation, or what we see is the hyperregulation or policing of African descendants' bodies through the medium of our hair. This is just one more example of the ways in which we are policed. And this is very much deeply connected to our racial and cultural identities as African descendants. These negative stereotypes and biases as it relates to our natural hair texture and hairstyles subject us to heightened levels of scrutiny, as you can see, discipline, harassment, and policing of our hair in schools, workplaces, and throughout broader society. As it relates to African descendant women and girls, it's really important to really examine the different types of consequences and implications of race-based natural hair discrimination, because ultimately, when you tell us that we cannot wear our hair in its curly or coily or locked or braided states, that you're really essentially telling us that we have to wear straightened hair. And a lot of people don't think about that as something that is extreme, is is burdensome. It burdensome at all. But imposing this kind of straight hair mandate or expectation upon African descended women in order to satisfy or in order to obtain and maintain educational as well as employment opportunities beyond other types of inclusion in broader society really do have some real consequences that are oftentimes not known or under discussed. And so these types of burdens that I'll talk about in just a second really are reflected in the Perception Institute's Good Hair Study, which found that 1 in 5 Black women feel social pressure to straighten their hair for work, which was twice as many as white women. Also, Black women report spending 9 times more money on professional hairstyling and hair products. We spend more time on our hair and have more professional hairstyling appointments than white women reported. Additionally, there are these invisible harms of race-based natural hair discrimination. For example, when we are straightening our hair, many times we are straightening our hair using chemical relaxants, as you see, starting at very early ages, as you see here with the young girl in the top corner, through extreme heat styling technology or techniques like the hot comb here, as well as flat irons that can be up to 400, 500 plus degrees Fahrenheit that we are using, not simply on our hair, but also it can be exposed to our scalp. And so many Black women and girls are experiencing chemical burns from chemical relaxants, as well as extreme heat styling. We are also suffering hair loss at extremely high rates due to not only chemical relaxants and hair straightening agents, but also wigs and weaves. Additionally, a leading cause of hair loss among Black women is traction alopecia, which is caused by constant abrasive pulling force on our hair. And when we're losing our hair and also suffering these types of physical harms to our scalps and to our hair shaft, obviously we are experiencing emotional distress, as well as having to incur some real financial cost in order to repair this harm. Additionally, the Good Hair Study reported that many Black women report that when they are having to conform to a straight hair expectation or mandate, that they disengage in exercise and other physical activities because of their hair. And you may say, why? Well, because of the time and energy and money that we're expending in order to maintain straightened hair. We don't want to perspire in it, and we don't want to mess it up. And additionally, because of, as you've noted already, hopefully, the negative consequences that come as a result if we are to wear our naturally curly or coily hair or other types of natural hairstyles. So many Black women report that they do not engage in physical exercise and activities. We refrain from those in light of all of these different types of potential consequences, as well as deliberations, and those can lead to chronic medical or health conditions by not exercising. Additionally, there are another study that indicates that Black women surveyed are more likely to commit to professional hairstyling than going to a physician, which too leads to negative outcomes as it relates to our health. There are also potential correlations to reproductive health matters. For example, possible linkages to higher rates of uterine fibroids, uterine cancer, hormonal infertility, and more aggressive forms of breast cancer among Black women, as well as increased hormonal activity among Black girls due to long-term use of chemical relaxants, as well as other types of hair products to maintain straightened hairstyles. So ultimately, what does this mean is that when we're talking about the enforcement of these negative biases and stereotypes, whether it's informally or formally through workplace policies, natural hair bans leave African descended women and girls, as it relates to educational policies, in a precarious catch-22. Either you don your natural hair at the risk of lawfully being deprived of an employment or educational opportunity, or you don straight hair at the risk of enduring consequential harms to your physiological, physical and psychological, as well as economic well-being. And so when I talk about this issue, I often say is if you care about Black women and girls' health, you have to care about our hair. And when I also talk about this issue, it really is important to think about the legality of this kind of race discrimination. Unfortunately, it is very much lawful under federal law for the most part to discriminate against African descendants on the basis of our natural hairstyles, except for the cases of afros, which I'll talk about just really quickly. And this is just one headline as it relates to a more recent case where an African-American woman was the subject of a petition that was going around in her workplace where people were asked to sign on to it if they thought that her natural hairstyles, and I believe she was wearing braids, if they thought that her natural hairstyle was unprofessional. And people signed this petition, and she challenged it and claimed that this was, this was amounting to a racially hostile work environment. But what we see the federal court saying is that even though it was offensive for her colleagues and her supervisors to circulate this petition calling her natural hairstyle unprofessional, it did not amount to unlawful race discrimination under our federal civil rights laws, like in this case, it was Title VII of the 1964 Civil Rights Act. So just to give you a little bit of background, Title VII of the 1964 Civil Rights Act prohibits racial discrimination in workplaces. And it's a very seminal civil rights legislation, the 1964 Civil Rights Act generally, but in particular as it relates to employment discrimination via Title VII. And many of these cases that largely African descendant men and women have been litigating for 40 plus years now, challenging natural hair bans or prohibitions against natural hairstyles like locks, braids, twists, and afros, have been met with a lack of success. And this year marks the 40th year where we have very instrumental legal precedent that declares that natural hair discrimination does not constitute race discrimination except for in the cases of afros. The most recent of these cases that really has served as one of the impetuses for the legislation and other types of legal and policy movement to combat race-based natural hair discrimination is EEOC versus Catastrophe Management Solutions, which is a case out of Alabama. And so in this case, Chastity Jones, as you can see here, was wearing blonde curly locks. She applied for a customer service position with an insurance processing agency, claims processing agency, and she was extended the job offer on one condition, that she cut off her locks. She refused to do so. She then lost that job opportunity. They rescinded the job opportunity, and she filed a claim with the EEOC's assistance of intentional race discrimination and violation of Title VII. In Title VII's prohibitions against race discrimination. And basically, like in a lot of these cases, what the employer told her was that, or it basically was expressing, was that her locks did not conform to their grooming policy, their written grooming policy that mandated that all personnel project a professional and business-like image, and that they could not don excessive hairstyles. So in sum, by telling her that she had to cut off her locks, they were telling her that her locks were excessive, unprofessional, and not business-like, and therefore unacceptable for the workplace. And unfortunately, the court agreed essentially by holding that this discrimination that she encountered on the basis of her locks did not amount to race discrimination, and ultimately employers were free to regulate and discriminate on those grounds, even though this has absolutely nothing, her hair has absolutely nothing to do with her ability to perform the job effectively. And so essentially what the court does is that they reify legal precedent starting from 1981, where basically the federal courts repeatedly have held that Title VII, as it relates to race discrimination, Title VII only protects against discrimination on the basis of immutable characteristics, or characteristics that you are born with, characteristics that only one, there we go. Characteristics that you cannot change, characteristics that are difficult to change, or characteristics that all individuals of a particular racial group possesses, or that they only possess, which is absolutely impossible. There is not one characteristic that a Black person will possess, or one who identifies as Black possesses, that, say, a white person or a person who identifies as white cannot possess, and vice versa. And a good example of that is an Afro, right? We know that there are individuals who identify as a white or European descendant who are rocking afros, right? And similarly, you have African descendants or those who identify as Black people who have lighter skin complexions and straight hair, similar to what we may often assign to whiteness. But what the court, this very sort of narrow and biological understanding of race, really perceives that there are these characteristics that only one particular racial group or members of particular racial groups can possess. And those are the kinds of characteristics that, if you're subject to discrimination upon, would be unlawful, but there really is none. And so this is why I call the immutability doctrine a legal fiction. It's very much shaped by these ideas, these false ideas as it relates to race. And so ultimately what the court says here is that, discrimination on the basis of a Black hair texture is an immutable characteristic, would be prohibited by Title VII and other federal civil rights laws, while adverse action on the basis of a Black hairstyle, a mutable cultural choice, is not. And so what that really means is that they perceive an Afro as being a Black hair texture, and therefore an immutable or unchangeable characteristic of Blackness, or a biological characteristic of Blackness. And so if you discriminate on the basis of an Afro, then that constitutes race discrimination. However, if you lock, braid, or twist that Afro and are discriminated against, then magically it's no longer about race. It is about mutable cultural choices. And since Title VII does not prohibit discrimination on the basis of culture, guess what? Discrimination on the basis of locks, braids, and twists are not unlawful under our federal civil rights laws. So employers and other actors that are governed by our federal civil rights protections against race discrimination are essentially free to police or engage in what I call the hyperregulation of Black people's bodies via the medium of our hair. And so what I've argued in my legal scholarship is that race is a social construct. It is not a biological construct. And that when we think about race and we think about the meanings associated with race, oftentimes they are coming from physical characteristics, characteristics that are changeable or mutable, sometimes characteristics that we are not born with, but nonetheless, we assume and perform, like our skin color, hair texture, our nose, our nose sizes, our lip sizes, our facial structure. Additionally, the ways in which we dress, our language, our accent, our speech, where we live, where we go to school, and even the names that are given to us or that we assign ourselves, oftentimes are very much associated with our racial and ethnic identities and serve as a basis for racial and ethnic discrimination or national origin discrimination. And this kind of discrimination, especially as it relates to discrimination on the basis of mutable characteristics, harkens back, centuries, harkens back to, in particular, as it relates to the Americas, to eras of racial slavery and European colonization. where we saw very early on in American history that early American jurists would basically demarcate in jurisprudence that physical markers, namely a woolly hair texture, would mark an individual as African descendant and therefore enslavable, while possessing straight hair that did not have the propensity of becoming woolly would mark an individual as white or indigenous and therefore free. So what does this really mean? Is that very early on in our history, in our legal and social history, is that if you had, say, a woolly hair texture or the propensity of it becoming woolly, even if you had a fair skin complexion, you could be marked as African descendant and therefore legally enslavable. And if you had a fair skin complexion and straight hair and that straight hair that did not have the propensity of becoming woolly, you could be marked as indigenous or European descendant and therefore free. So literally, our freedom in this country has been very much connected, not only to our skin complexions, but also even independent of our skin complexions, the texture of our hair. And so hair has served as a critical site of racial classification, a critical site of racial subordination, as well as racial discrimination, not only in this country, but again, around the world. And so in light of this history, what I have argued in my scholarship, and as you can see, that has been cited in federal court jurisprudence, but also more recently by John Oliver, is that, this idea that race constitutes only immutable characteristics is flawed, number one, and that race really is a social construct, number two, and number three, when we think about race, we really need to think about the fact that there are appearances and behaviors that historically and contemporarily that are commonly associated with a particular racial group, even when those physical appearances and behaviors are not uniquely or exclusively performed by or attributed to a particular racial group. And so when we think about this understanding that essentially race is not about biology, number one, but race is very much a social construct, and we affix certain types of meanings, both positive and negative, to characteristics, and can serve as a basis, and often do serve as a basis of racial discrimination. And so this definition of race, though it has been cited by courts and other types of enforcement bodies and agencies, has also been an iteration of this definition has been adopted in legislation known as the Crown Acts, but as well as other types of legislations not denominated as such. And so in California's Crown Act, which was the first one to be signed into law, it defines race as traits historically associated with race, including but not limited to hair texture and protective hairstyles. Since California, there are now 10 states that have passed legislation that clarify that natural hair discrimination is race discrimination in a variety of contexts, whether it be employment or housing or even in education. And one of the most recent victories to free the hair is in Nebraska, which again, I had the privilege of assisting with in the drafting of the legislation and advancing there. Additionally, it has been happening on municipal levels, on local levels. New Orleans is another great example of this, where it is the first city in the Deep South to have passed a Crown Act, which with the amazing support of Citizenship United Executive Director Nia Weeks and Council Member Helena Moreno there. And this just happened in December of 2020. In addition to that, we've had numerous states, now I believe it's about 17 or 18, municipalities, 17 or 18 that have passed their own types of ordinances that address race-based natural hair discrimination, making it unlawful in those localities. in addition to that, we have also had really instrumental and groundbreaking enforcement guidance by state as well as municipal and federal enforcement agencies like the New York City Commission on Human Rights in February 2019, which was the first enforcement agency in the country to issue enforcement guidance that expressly declares natural hair discrimination, as well as discrimination on the basis of cultural attire and hair coverings constitute unlawful racial discrimination, not simply in workplaces, but also public accommodations, as well as private and public schools. And on the federal front, I'm happy to report that the Federal Crown Act, again, that I had the privilege of helping to draft and advocate for, clarifies that characteristics that are commonly associated with race and national origin, discrimination on those grounds would constitute unlawful discrimination under our federal civil rights laws that protect against discrimination in workplaces, housing, public accommodations, as well as discrimination engaged in by federally funded institutions. This bill was passed by the United States House of Representatives in September of 2020. And in light of the new legislative session, it had to be reintroduced, and it was just reintroduced in March of 2021 by these wonderful advocates that you see at the bottom of the screen here, Representatives Presley, Omar, Moore, Lee, and Watson Coleman have reintroduced this legislation. Also, I thought it would be interesting to see, or important to note, that it is extended beyond, legislation and enforcement guidance. Also, we see here these resolutions from really important organizations and associations like the American Bar Association, which too drew upon my legal scholarship in this area to really advance the interpretation that race in our anti-discrimination statutes be not limited to the color of one's skin, but rather include other physical and cultural characteristics associated with race. They also encourage these very conversations that we are having right now within the legal profession as it relates to discrimination on the basis of not only texture and style of one's hair, but also the appearance of one's hair, and really tackling the implicit as well as explicit biases, whether it be on the basis of race or religion or sex, gender, among other types of identity characteristics. And they ultimately support not only this legislation, but the clarifying guidance and definitions that are being adopted in this legislation. Even more recently, I will say another groundbreaking movement as it relates to litigation is, many of you might be familiar with Caden Bradford and his cousin DeAndre Arnold, who were subjected to race-based natural hair discrimination at their school in Texas. DeAndre Arnold in particular was told that he would not be able to participate in his high school graduation unless he cut off his hair. They also were subjected to a lot of discipline and ultimately suspension and expulsion from the school district that they had been attending since their pre-K years. And I served as a legal expert in this case that was brought on their behalf by the NAACP Legal Defense Fund. And for the first time, to my knowledge, we have a federal court that declares and affirms their constitutional rights to be free from this kind of discrimination, not simply because it amounts to a violation of our Constitution, in particular the 14th Amendment that prohibits race discrimination as well as sex discrimination, but also it is an infringement upon their First Amendment rights to cultural expression. And it was very much this decision by the Federal District Court in Texas was informed by a lot of in a longer format, but much of the work that I've shared with you today in showing that African descendants' natural hairstyles can be an expression of our cultural and racial identity. In the workplace front, in my last few minutes here, is that I did want to talk about policies that have been changed in light of this galvanizing movement to combat race-based natural hair discrimination, and also in conjunction with the racial reckoning that has been coming about in light of Black Lives Matter movement and greater levels of increased awareness as it relates to racial inequities in this country and beyond. And so UPS is one of the major companies that has disbanded their ban against natural hairstyles as it relates to their employees. And I'll have to say this was pretty momentous because they have spent many years not only litigating their right to discriminate on the basis of natural hairstyles, but really actively defending their legal right. And they've been successful in light of the federal jurisprudence that I talked about earlier. And so in listening to the feedback from their employees, and also I imagine in light of all of the things that have been going on socially as well as politically and legally, they decided to change their grooming policy that barred natural hairstyles as well as barred the male drivers from wearing beards or facial hair, and additionally really bringing about more robust policy as it relates to respecting one's cultural and religious expressions. And recently I had the opportunity to talk with JP Morgan, and they shared with me that their affirmation as it relates to allowing individuals and really just affirming individuals' choices. I won't just say allowing, but affirming individuals' choices, needs, or desires to wear their natural hairstyles like afros, braids, twists, and locks, that they should be respected in the workplace. It should not be a basis of discrimination. And lastly, wanted to share with you some movement that is happening in the UK. The Halo Collective, which is an organization whose mission is very similar to mine, is to end hair inequality for good. And they too have been circulating what they have called the Halo Code, and asking different corporations and organizations to sign on to the Halo Code and to adopt and integrate this code in their workplace policies, and to really implement it and institutionalize it as a workplace cultural norm, and which is to say our workplace champions the right of staff to embrace all Afro hairstyles, and acknowledging that Afro textured hair is an important part of our Black employees' racial, ethnic, cultural, and religious identities, and requires specific styling for hair, health, and maintenance. And therefore goes into talking about the celebration of Afro textured hair, as well as recognizing and celebrating this as a part of their ethos of equality and respect and dignity. And I will argue that this is something that many workplaces as well as other organizations are really going to have to contend with, because as we are becoming more free, free in the sense that we are seeing that we're I won't say no longer, but that we may no longer be on lockdown and in quarantine. What you will likely find is that through these quarantine months, that many of your employees, not just Black women, but also Black men too, have been freeing their hair, in large part because they have not been able to go to hair salons and barbershops, but have nonetheless still been maintaining their hair in healthy ways, and in particular, really adopting and embracing natural hairstyles like afros and braids, twists and locks, Bantu knots, among others, that they may not have done before quarantine. So that means that in light of all of this, what it means is that as Black women and men are showing up in the workplace with their free hair and freely rocking their natural hair, is that we must all engage in what I call the business of respecting one's personhood. One that this business, this particular model coming from civil rights pioneer and shero here, Polly Murray, because she says the business of oppression is not respecting one's personhood. And what I really would hope is that as we are all thinking about increasing and embracing greater levels of inclusion and belonging and diversity and equity in our workplaces and other spaces, that we no longer engage in the business of oppression by not respecting one's personhood, and ultimately allowing people to free the hair. Thank you. And I'll open it up to questions now.
Yes, thank you so much, Wendy Greene, for sharing just that wealth of information. At this time, I would like to let our attendees know that the Q&A button is present for you to use and type in any questions that you want Professor Greene to address related to her comments today, or any other questions for her. We prefer you use the Q&A button versus the chat function. We can sort of track questions better. So if you've got questions for Wendy Greene, now is the time, and she's available to address them. But I have to say, Wendy, that I just think that even for me, this has been an enlightening discussion, and we so appreciate you know, what you shared with us today. When I first, and we've had several conversations about hair together, but when I first sort of understood the work that you were doing, I, you know, thought it was an issue of cosmetics. You know, these people want to, yeah, some folks want to wear hair this way or that way. And when you kind of go in depth, you realize that this is really the way the hair grows out of our head. And why should we be made to permanently alter that in order to function in society like all other people? It's not so much a cosmetic issue, you know, but it is one of definite freedom and authenticity. When you think about managing a characteristic that probably has little to no relevance in someone's work skills and all of the other. So I appreciate your taking the time to share that with us. I see that there are some questions that are coming. So perhaps Danielle, you could share what some of them are.
Sure. So our first question is, Professor Greene, do you have any suggestions or resources for how to start the conversation about natural hair discrimination among people who may not have given it any thought?
Sure. Well, aside from the fact that I've written a lot about it, so I will say I'm happy to share publications. I do try to make them accessible. I know some people might kind of gloss over when you talk about law review articles, but you know, I will say that at least my goal has been to make them accessible so people can really appreciate all of the different dimensions of natural hair bias, race-based natural hair bias, stereotypes, and discrimination. So that's one point. There's plenty of, you know, written materials that you could share independent of my law review articles. I was just kind of playing, but but not really. But there are plenty of articles out there, as well as books that address this issue, which I'm happy to share with the Literacy Council on this issue. Additionally, there are documentary short ones like the one that I showed today from Law 360. Adrian also mentioned it's about 9 or 10 minutes long video, but I thought they did an excellent job. PBS NewsHour special on it. If you kind of want some biting humor with it too, then the John Oliver Show is another one. I don't know, be prepared. You kind of have to know your audience for that one, but happy to share.
No children in the room on that one.
This is true. You don't want any children in the room. But there's so many different materials, and those are just a starting off point. Obviously, there are materials between, you know, studies, if depending on the kind of conversation that you want to have, that I also can share by the Perception Institute, for example, Duke University study. There are some seminal pieces from starting from the 1990s into, you know, into the early 2000s too, as it relates to natural hair bias and discrimination, and the history as it relates to Black people, you know, Black people's expression of their, not just simply racial and cultural identity, but oftentimes, you know, our religious identity. It could be a signal of our socioeconomic status, our hair, addition to the status that we may, the statuses that we may have assumed or been conferred upon us in society too. So one point I want to say is that, yes, we have suffered a lot of discrimination on these grounds, but there's been a lot of affirmation and celebration too. There are a lot of good things as it relates to the expression, our expressions, lots of different expressions via our hair. And so there are also materials that talk about that too. You know, some people like to use, my last little note, some people like to use Chris Rock's, you know, good hair as a way to start a conversation.
Wendy,
Yes,
I don't mean to cut you off, but I will tell our attendees that I just put in the chat 3 links. One is about your scholarship, but one includes that PBS link that can show that 9-minute, you know, detail of what you were expressing. But go ahead about Chris Rock. What were you saying?
No, I mean, and also a very comical look on it, but I mean, he doesn't really get into all of the details as it relates to natural hair bias and discrimination, but really does kind of really illuminate the privileging of straightened hairstyles in the wig industry, the huge wig industry. And then there are a few other documentaries, longer documentaries, like Back to Natural too, which I would highly recommend. So those are just some things off the top of my head, but again, I am happy to provide resources. And then additionally, I've been a part of these conversations in corporations where they have had some of their employees, for example, with Home Depot, as well as with JP Morgan, where they have had sort of a pre-reading or a previewing before having the conversation on natural hair bias and in the movement to combat race-based natural hair discrimination. And even Home Depot decided to do a 2.5 day long celebration of Black hair, and did, you know, had several types of events over the course of two days. So what I will say is that it has to be an ongoing conversation, right? Like any other issues as it relates to equity and inclusion. It's not, you know, I would not sit here and say we just need to limit it to, say, Black History Month or to the one day in September that we want to talk about it. It has to be an ongoing educational and enriching conversation.
One thing that I can say that I noticed about you know, the last parts of your presentation that I thought were powerful were how some companies have affirmed, just simply affirmed the professionalism of all Black hairstyles, and they've done it in a concrete way. They've put out statements. They have actual visual imagery that says this locked style is professional, this or that or the other is professional. And I think that having things that the whole workplace can view and understand or consider professionalism on the part of the employer can be a positive way of combating what might be bubbling within, you know, different little parts of the employees' cliques and such. So I thought that as well as UPS's willingness to redirect what had been things that they litigated to for really the opposition of these types of policies. They have been litigating that, and then they actually turn around and begin affirming it by allowing and loosening up all types of allowances for what Black hair can really
Mhm.
be, or from people of color.
Mhm.
And that's in an environment that's typically male.
Mhm.
So
Mhm.
I like seeing both of those things.
Yeah. Yeah, well, I will say they did not have the pictures. I put those on there, but I will caution people as it relates to putting pictures in policies, especially if you're trying to say what you cannot do and what you cannot wear, because because I've seen those, and it's very stigmatizing, and just undignifying if you have a picture of a hairstyle, for example, like a locks or braids or the twist, or like in the cases of in the Atlanta public school system, one of the schools had pictures of braided hairstyles. Also, if you had designs in your hair as Black boys, that they were considered to be unacceptable and in violation of their grooming policy. So to the extent that you're going to use pictures, let's use them in an affirmative way, as opposed to a way that serves as the basis of discrimination. It'd be one that serves as a basis for signaling inclusion and belonging and welcoming of not even just natural hairstyles, but even if, this extends beyond that, as you can see that, individuals are being subjected to discrimination on the basis of their religious expression that includes appearance and grooming, right? And so in workplaces, demonstrating that you are affirming one's rights to religious expression and that you will accommodate racial and cultural expressions if for some reason they do sort of create some tension or conflict with your grooming and appearance policies, especially as it relates to health and safety. But again, really just trying to show that you are in favor of, that you understand that these types of grooming and appearance choices and desires and sometimes necessities are respected, and that you will make the critical decisions to accommodate and to include those individuals when they are engaging in such.
We do.
Thank you
plan
so
on-
much. Yes, thank you. Thank you, Professor Greene. We have another question. It says, hi, Professor Greene. Can you talk a little more about company policy, please? How do we create and affect change in our companies?
Well, so those are just a few examples of policies that are expressly affirming one's religious and cultural expressions. Additionally, I would say for written policies, grooming policies that dictate that say unprofessional or extreme or unusual hairstyles and hair colors need to be revisited, right? Because we need to know why you have that language. Is it to target particular individuals that you perceive as being extreme or unusual or unprofessional or unkempt? And oftentimes, what does that mean? They are rife with stereotypes, racial and ethnic, and sometimes gender and religious and age even, and as well as disability, stereotypes and biases, right? So we really need to really try to tackle why do we even have this policy for starters. Secondarily, how is it being enforced? Are you only regulating certain individuals? Are you only regulating certain individuals and policing certain individuals as it relates to their appearance and their grooming, which can ultimately lead to some claims of discrimination on different types of grounds? So that too. And thirdly, is it really even necessary? I imagine it's probably not. I believe that oftentimes these formal written policies, these neutral policies that talk about not allowing extreme and unusual hairstyles and hair colors, to really, to be clear, it's a function of control, right? And it's a function of control and what we believe is unlimited or boundless employer prerogative. And a function of actually, oftentimes treating our employees as if they are not human and that they are your property. And I would really, really challenge employers and organizations to really interrogate, the impetus and the motivation, as well as the enforcement of those types of grooming policies. So that again, if your goal is to really bring about diversity, true diversity and inclusion and belonging in your workplaces, this is just one of those ways that can actually undermine that, and one of those ways that we often don't even think about, right? So those are just some of my initial suggestions in terms of how we can effectuate real policy change that ultimately, hopefully, will result in institutional change as it relates to our cultural norms and practices too. And so that's just something else to consider. Yes, Adrian.
No, we're beginning to round it up to the end of our session, unfortunately, and we can certainly, distribute any answers to additional questions that you have. We can do a follow-up type meeting with our attendees here, but we would also like to remind everyone that this does touch on reading, and as we have mentioned in the conversation today, writing as well, because we do have to inform ourselves. And we do have to have the capacity to reflect on how this impacts our environment. So we are giving a book out that actually might address some of the questions that have been asked today. It will be, distributed to our attendees, in a time after the show. But we've chosen How to Be Anti-Racist, which is a book by Ibram X. Kendi that has gotten much national and publicity and is present in a lot of formats. But the great thing that I love, not only will be reading this book, but we would also be writing in this book, because we have a workbook that we would also share with all of our attendees, so that you can begin to reflect on how this issue, which may be just one issue that is sort of an emerging issue for you in terms of institutional racism, how these policies build upon each other and create a whole segment of the way organizations behave. There may be something else bubbling up. And if you reflect with Ibrahim's book and his actual workbook, perhaps you can begin to make a plan and a strategy for how you want to combat anything that is not positive for all of your employees. You may develop policies that are affirming for your employees. This book will outline how to do it, and wish we had it, so that people could really think concretely about hair discrimination issues. So we can continue on with this issue and do more research, and also strategize and reflect through the workbook. We so appreciate you coming today, Wendy Greene, Professor Wendy Greene, and sharing all of your knowledge. And we appreciate the attendees for taking time to learn about this issue. Thanks so much.
Thank you. Free the hair.
Free that hair. Good day, everyone.